Yeah. Well, the bottom line is the two triggers. If you own a house, if you have any kind of real property or you have children, you probably need to have a trust-based plan. And talking about, real estate holdings, I've had situations where, and this comes up a lot in blended families. And when I first started practicing law, blended families wasn't so much the norm. And I got to tell you, today, blended families are probably the norm. So what happens when the complexity that you have when you're dealing with a blended family, and it just happened, one of my clients passed away, and his wife, who is second wife, okay, has the right now to live in what was his separate property residence until she passes away. And then, when she passes away, that residence goes to his children from his first marriage. And, having the estate set up to take into account that eventuality is very important, because what happens if you don't have the estate set up properly, and let's say the house, which was clearly a separate property asset, is left to a second wife, and then second wife doesn't do anything to protect that for the children, you can basically unintentionally disinherit your children in that kind of a scenario. And if you want to look at estates where that happened, everyone's heard of Marilyn Monroe. Well, when Marilyn Monroe got married, lo and behold, she had a significant separate estate. Didn't have any kids. When she passed away, it rolled down to her husband. Well, her husband got remarried. And when he passed away, all of the money that Marilyn Monroe had was in his estate and ultimately went to his new wife's heirs. And you gotta know in your heart that Marilyn Monroe never intended for the bulk of her estate to go to this woman's heirs, but it happened. People, when they put their house in the trust, generally it's got a mortgage on it. And when you transfer title, right, that's a transfer of title, a mortgage company could come and say, well, wait a minute, you just transferred the property to a new owner. That triggers a due on sale clause. There's federal legislation that says, no, that's not the way it works when you put the property in a trust. Same thing with respect to property taxes. When your attorney files the new deed transferring the house from you as husband and wife as joint tenants to husband and wife as co-trustees of their new trust, there's a form that you have to file with the tax assessor's office that says, wait a minute, this isn't a sale, this is just a transfer to a trust. And again, the do-it-yourselfers sometimes mess this up. They don't know about that form, they don't file that form, and they go ahead and file the new deed, and the property tax assessor just sees the deed with no form that says it's an exempt transfer, and guess what? A couple months later, they get a supplemental tax bill in the mail because now the property has just been reassessed to its current fair market value. And to try to unwind that mess is a nightmare. It's possible, but it's a difficult process. So again, doing it yourself, sometimes there's minefields that you got to be careful about, and that's one of them.